Back here at home, today, the Colorado Supreme Court will hear oral arguments on whether former President Trump should be allowed on the primary ballot in that state, given his role in the January 6th insurrection.
Yeah, so this hearing comes after a Colorado District Court judge ruled that Trump should be allowed to be on the state's ballot next year, even though he, quote, engaged in insurrection. But the plaintiffs argue the former president should not be on the ballot because he violated Section 3 of the 14th Amendment, which bars people from holding office if they've engaged in insurrection against the U.S., something Mr. Trump has not yet formally been charged with.
For a look at what we can expect next in this case, we're joined now by Neama Rahmani, former federal prosecutor and president of West Coast Trial Lawyers. That's a law firm based in L.A. Neama, welcome to Morning Rush. Good to have you. It's a fascinating issue just on its own face, and something that we as a country have never had to deal with before in terms of a former president and a presidential contender who could be president again, depending on how we all vote. So talk about what is at stake, not just in this case, because depending on what Colorado does, it could have a domino effect on other states around the country contemplating these very same actions when it comes to Trump. What's at stake here?
Yeah, Rob, it's obviously a very complex and novel legal issue. I mean, this statute hasn't been used since the Civil War, and the judges that have considered it are all over the place. You've had judges that said that voters don't have standing to bring these Section 3, 14th Amendment challenges. You have others that have said, well, it may prevent Donald Trump from running in the general election, but there's nothing in the 14th Amendment that says he can't run in the primary. You have others that have said that's a matter for Congress, and Congress chose not to impeach Donald Trump. And of course, in Colorado was the most unique decision of all. You had a judge that ruled that Donald Trump actually engaged in the insurrection, but he is not a federal officer. The office of the presidency is not, it only applies to the lower federal positions. So that was a surprise and a head scratcher, to say the least. So now we're in front of the Colorado Supreme Court. They're going to hear oral arguments today, but this case is almost certainly going to end up before the United States Supreme Court because it's such an important constitutional issue, and the decisions, they're all over the place.
Yeah, I mean, so what precedent then does this set moving forward? I mean, hopefully we never experience a day like we did on January 6th ever again. But when you say that, you know, yes, he did engage in insurrection, but he was not an officer at the time, I imagine that sets a pretty, not that great of a precedent.
Not a good precedent at all, because this is the first judge that has ruled as a matter of law that Trump did engage in an insurrection. And of course, despite all his criminal charges, no prosecutor has charged him with insurrection or seditious conspiracy. He's been charged with other crimes. But now you have a judge that has said, well, no, you actually are an insurrectionist. So, you know, if a higher court takes that and runs with it and says that it does apply to the office of the presidency, then he would be barred from running for a public office, including president next year. And there's going to be a significant percentage of the American public that would be very upset with that result. And essentially, Republicans would have to find another candidate next year.
And it's I think also worth noting, and I know that this gets in the weeds a little bit here, but when Special Counsel Jack Smith brought his case, he kept it very narrow, unlike the case here in Georgia. And he specifically decided not to charge Trump with the insurrection because that would be the one charge he could bring, because of what you just said, that he could potentially keep Trump from the Oval Office again if he were convicted on that charge. Because he didn't want to give fodder to critics who say, you're doing this for political purposes. So he went with the election interference-related matters, not the insurrection matters from January 6th. It is important to note that. But at the same time, as you said, we have a judge on the bench saying, you did engage in insurrection. So again, it's a mixed bag, but I wonder too, if it gets to the Supreme Court, which of course it will, and a third of that court, now Trump appointees, if it got to the court, if it got to the nation's highest court, what do you think they would do? Because essentially they would be telling the guy who got them that seat can't be president again. There's a conflict there.
Well, I agree. And for talking about Jack Smith, you're right. I mean, his indictment in Washington, D.C., very surgical, right? Not just in terms of the number of charges, but in terms of the number of defendants, right? It's just Donald Trump. He didn't charge all those co-conspirators and co-defendants like Fonnie Willis did in Fulton County there. Now, if the case does end up in the Supreme Court, and I fully expect that it will, Absolutely. We're talking about a 6-3 court in favor of the conservatives. So the chances of the Supreme Court justices keeping Donald Trump off the ballot is low. I mean, these cases, a lot of talking heads like myself have thought really it's a legal Hail Mary. The chance of success is low because Trump hasn't been charged, much less convicted of engaging in an insurrection. So for a judge to rule that as a matter of law, that's a bridge too far for a lot of folks.
All right, Neama Rahmani, a former federal prosecutor and president of West Coast Trial Lawyers. As always, good to have you on the show. Thanks for coming on.
Thanks for having me.